Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt. On the radio, on podcasts everywhere, on Facebook, on YouTube, and on talklawradio.com. Today we're going to be talking about a Texas law that outlaws gender modification, because this could be a hidden legal issue blind spot. And it's my job to help you identify those blind spots before you fall into one. And this Texas law was passed, enacted in 2023, but it's resurfaced again. And so I'm going to tell you why and how. But let's start with some of the provisions from the law in case you've forgotten. Now, I did talk about this last June in 2025 because there was a Supreme Court case that addressed it. But I'm going to go back to the law so that we can really identify what's prohibited. There's one statute, Section 62.151 of the Texas Health and Safety Code, that says a child health plan may not provide coverage for services prohibited by Section 161.702, which we'll get to, that are intended to transition a child's biological sex as determined by the child's sex organs, chromosomes, and endogenous profiles. Then we get to Chapter 161 of the Texas Health and Safety Code, and this is where Section 161.702 is, which is the prohibition. Prohibited provisions of gender transitioning or gender reassignment procedures and treatments to certain children. A physician or a healthcare provider may not knowingly perform a surgery that sterilizes the child, perform a mastectomy, provide, prescribe, administer, or dispense any of the following prescription drugs that induce transient or permanent infertility, or remove any otherwise healthy or non-diseased body part or tissue. And there are some exceptions. With the consent of the child's parent or legal guardian, physician or healthcare provider may, these are the exceptions, provide puberty suppression or blocking prescription drugs for the purpose of normalizing puberty for a minor experiencing a condition, or appropriate or medically necessary procedures or treatments to a child who is born with a medically verifiable genetic disorder of sex development, or does not have the normal sex chromosome structure for male or female, as determined by a physician through genetic testing. So this is the Texas law that prohibits gender modification or gender transitioning, whatever you want to call it. It was Texas Senate Bill 14 in 2023, and now it's in the Texas Health and Safety Code, Section 161.703. And the reason I'm talking about it is because there was a new Texas Supreme Court case, and I'll get to that in just a minute. There was a law that challenged the constitutionality of these provisions. And so I'm just wondering, is this something that you would support? If it is, post a comment on my Facebook page or email me at host@talklawradio.com. That's HOST@talklawradio.com. And by the way, I have a Saturday show. It's at 11 o'clock in the morning on 9:30 a.m. The Answer, 6:30 a.m. The Word in San Antonio. Also, KNTH 1070 in Houston and 103.3 FM in Houston. So if you have friends in Houston, send them a text message, encourage them to listen to Talk Law Radio. Because in the beginning, God had one law: don't eat from the fruit of that tree. Then he gave Moses the 10 Commandments. And now we have municipal, state, and federal lawmakers that won't stop creating new laws that might impact you without you knowing it. So that's why I do this. It's all for you, to help you know the law, because there's so many laws. Anyway, back to the law at hand. Texas Senate Bill 14. Also, it's codified in Texas Health and Human Safety Code 161.702. So there was a lawsuit that challenged the constitutionality, and it was a case known as Texas versus Lazaro Low. There were a bunch of different defendants, but that was the first one. This was back in June 28th, 2024. So the Supreme Court addressed this, whether it was constitutional. Before the law took effect in September 1st, 2023, several parents of children with gender dysphoria, together with physicians and groups that would be affected by the law, sued to stop its enforcement, alleging it was unconstitutional. And the trial court in Austin concluded that the law likely violated the Texas Constitution, and so it stopped the enforcement of the law. And the Texas Supreme Court's job was to determine whether the plaintiffs in that case had established a probable right to relief on their claims that the legislature's prohibition of certain treatments for children suffering from gender dysphoria violated the Texas Constitution. The Texas Supreme Court in 2024 concluded that plaintiffs failed to meet that burden. The Texas Supreme Court held that fit parents have a fundamental interest in directing the care, custody, and control of their children free from government interference. Everybody likes that part, but the court never defined the source or precise scope of that interest of the parents, and so the interest is not absolute. The court held when developments in our society raise new and previously unconsidered questions about the appropriate line between parental autonomy on the one hand and the legislature's authority to regulate the practice of medicine on the other, the Constitution does not render the legislature powerless to provide answers. The court concluded that the legislature made a permissible, rational policy choice to limit the types of available medical procedures for children, particularly in light of the relative nature of both gender dysphoria and its various modes of treatment, and the legislature's express constitutional authority to regulate the practice of medicine. The court concluded the statute does not unconstitutionally deprive parents of their rights or of physicians or healthcare providers or of an alleged property right in their medical licenses or claimed right to occupational freedom. The court concluded the law does not unconstitutionally deny or abridge equality under the law because of sex or any other characteristic asserted by the plaintiffs. Then, after that Texas Supreme Court case, there was a United States Supreme Court case called United States versus Skermetti. And this was a judicial review of a Tennessee law that did the same thing. And so this was a review of a Sixth Circuit of Appeals Court. And there's some interesting information in this case as well. I was just reading it. The court found certain facts, and this was decided in June 2025. If you want to go back and listen to my episode from June 2025, just search for podcasts everywhere, Talk Law Radio, Gender Dysphoria, and you'll find at least a YouTube video of it. Depends on whether you like to listen to podcasts or watch YouTube videos. You can go to YouTube, click the magnifying glass, search for Talk Law Radio, look for the Lady Justice logo and the red, white, and blue colors. So back to United States versus Skermeti. The court found that an estimated 1.6 million Americans over the age of 13 identify as transgender, meaning that their gender identity does not align with their biological sex. I just thought that was interesting. 1.6 million Americans over the age of 13. I had no idea. Do you know somebody that wants to change their gender? Doesn't seem to be uncommon these days. Well, in this Supreme Court case, the court held that Tennessee law was constitutional. And so that just reaffirms the Texas law and that it's constitutional. So this is now the law of the land in Texas. The Supreme Court affirmed a lower court's decision upholding a Tennessee law that prohibits healthcare providers from administering puberty blockers and hormones to minors experiencing gender dysphoria regardless of their sex. It held that there was no sex discrimination. It says rather on the medical treatment itself, which is prohibited for certain uses regardless of the patient's sex. So we know that the law is good. So then there was a court case in Texas where the Attorney General, well, back to the other Texas case. I'm sorry, forgive me. So there was the Texas case. Let me see here. That was Lazaro versus Texas. There were certain groups involved in that case, remember, that would be affected. Well, one of those groups, when they responded to the lawsuit in Austin, they submitted an affidavit. And in that affidavit, they were describing how people were going to be injured if this law were in fact upheld. It was an affidavit from the executive director stating that after the law's passage, families with adolescent children began contacting the organization PFLAG. I'll see if I can find what that stands for here. Well, I'll have to come back to that. So anyway, in the affidavit, the executive director stated that after the law's passage, families with adolescent children began contacting the organization PFLAG to share plans to move or to seek both in-state and out-of-state options to obtain gender modification procedures. New families showed up in droves for chapter meetings and support groups seeking information and support. Chapters planned and participated in events to provide comfort to and celebrate the unbreakable joy of the gender-diverse community. PFLAG families with transgender and non-binary adolescents shared their contingency plans, those with the resources to move or seek care out of state have begun firming up their plans to do so, while the vast majority without those resources have begun asking chapters for alternative avenues to maintain care in Texas. Families were not just seeking healthcare providers who specialize in medical care for gender dysphoria, but leads on affirming general practitioners as well, so that their adolescents would have access to multiple providers in the event that their primary providers stop providing gender-affirming medical care. So the Attorney General read that affidavit and said, hey, there's something going on here at PFLAG. They're giving advice to these families about how to break the law, basically. So the Attorney General's office sought to determine whether medical providers are misleading insurers, because remember, the law prevents insurance companies from paying for medical care that changes a child's gender, and others by billing statements outlawed by Senate Bill 14. The Attorney General's office employed its investigatory authority under the Deceptive Trade Practices Act to send a letter to PFLAG asking for information. Investigations of this nature have generated at least 3 lawsuits filed by the state against doctors alleged to have violated the Deceptive Trade Practices Act by prescribing hormones to minors in violation of Senate Bill 14, and then deceptively billing insurance companies for treatment of endocrine disorders or other conventional sounding ailments. According to the Attorney General's office, particularly its reference to conversations about the passage of Senate Bill 14 about alternative avenues to maintain transgender care in Texas, gave rise to a belief that PFLAG may be in possession of information relevant to the office's investigation of Deceptive Trade Practices Act and Senate Bill 14 violations by medical providers. So the investigation document sought documents and communications that form the basis of or relate to the director's personal knowledge of the information contained in the affidavit. It was asking for communications to or from any PFLAG representative relating to or referencing contingency plans or alternative avenues to maintain care, as those phrases were used in the affidavit. The Attorney General wanted all recommendations, referrals, and/or lists of pediatric and/or adolescent healthcare providers in Texas that PFLAG has created, maintained, received, or distributed since March 8, 2023. In reference to the affidavit, produce all documents, meeting minutes, and communications that support the director's sworn statement that PFLAG families with transgender and non-binary adolescents have been asking for chapters for alternative avenues to maintain care in Texas. So they were asking for all this information, and PFLAG filed a lawsuit asking the court to stop the Attorney General from getting that information. And the Supreme Court of Texas said that no, that's okay for the Attorney General to do, because they have that investigatory authority under the Deceptive Trade Practices Act. And the court went on to say that it's not the court's job to determine whether the Attorney General should investigate that, only that the Attorney General could. And so this is interesting to me because this could be a hidden legal issue blind spot, even if you're not wanting to change your gender, because the Attorney General could be investigating all kinds of things just by using its authority to ask for documents and information. And so you just need to be aware of that when you file affidavits in public court records. Whatever you say can and will be used against you. You probably heard that on TV, right? And so This also got me thinking, since the legislature can prohibit doctors from providing this care, and the legislature can prohibit health insurance companies from paying for this type of care, I thought maybe somebody out there would want to put a provision in their trust that prohibits the trustee from paying for this type of care, because one of the general types of provisions that says what's permissible for the trustee to pay for, we call it the ascertainable standard. It's health, education, maintenance, and support. And so the trustee would use its discretion to pay for things for your beneficiary if it falls under one of those categories. Well, health is one of those categories. And so I wondered if somebody out there would want to prohibit their trustee from paying for gender reassignment surgery or whatever they call it. And so I came up with an example provision for a trust, and it can be modified. But if you're interested in this kind of thing, if you already have a testamentary trust in your last will or living trust, and you know that there's enough money in that trust to go for generation to generation, and you don't want your hard-earned money spent mutilating children, changing their biological sex, then you can call Marquardt Law Firm at 210-530-4278, 210-530-4278, or search online marquardtlawfirm.com. That's M as in mother, A-R-Q-U-A-R, D as in David, T as in Timothy. And one of our attorneys will talk to you about your goals and your concerns and your objectives. I like to ask my clients, does it matter to you how your beneficiaries use their inheritance? If it does, you can put guidelines on how that money is spent. And if you name a trustee to make those decisions, to use discretion to decide what health, education, maintenance, and support means, you can also give them guidelines about what they should not do. And so I just kind of thought of a provision that would tie it to this Texas law, because this Texas statute already has definitions of these things, and so you don't have to be terribly creative. But part of it, I won't read the whole thing and bore you to tears, but for purposes of this example provision, child means an individual who is a child within the meaning of applicable Texas law at the time the distribution is requested. Prohibited service means any service, treatment, procedure, medication, or related item or expense that is prohibited by Section 161.702 of the Texas Health and Safety Code. That's easy. And is intended to transition the child's biological sex as determined by the child's sex organs, chromosomes, and profiles. The trustee shall deny any request for any distribution that the trustee reasonably believes would fund directly or indirectly a prohibited service. So there you go. I just created a whole new market of people that don't want their children, grandchildren, and great-grandchildren to be using their hard-earned money to pay for gender identification, whatever you call it, transitioning, child mutilation. I just think it's awful that kids have to go through this, because if you've known children before, you know that they change their mind and they go through periods of time where they want to do one thing, and then 6 months or a year later they want to do another thing. I hope you've enjoyed the show. Tell your friends about Talk Law Radio. Tell them to go to Podcasts Everywhere, Facebook, YouTube, or talklawradio.com. I'm Todd Marquardt. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Most families don't realize they have hidden legal blind spots until it's too late. Wills, trusts, Medicaid planning, even protecting a business. These are the kinds of issues attorney Todd Marquardt helps uncover before they become problems. Todd is the host of Talk Law Radio, where each week he guides listeners through the legal challenges families, veterans, and business owners face, while showing them the practical steps to protect what matters most. Catch Talk Law Radio, Saturdays at 11 a.m. on 9:30 a.m. The Answer, 6:30 a.m. The Word, and now in Houston on AM 1070 and 103.3 FM The Answer, or anytime on YouTube. Planning isn't just about documents. It's about peace of mind, security for loved ones, and building a legacy that lasts. Don't wait for a crisis. Do it before you die.